We have on the agenda House Bill 229, House Bill 713, House Bill 725, and I think it's 1074. Is that right, Mr. Strickland?
Mine's 229.
229, okay. First one, okay. And first up is House Bill 229, sponsored by Representative Strickland.
Here or there? Do you have a preference?
What's that?
Do you have a preference where I sit or stand?
Whatever is good with you is good with us.
All right. Thank you, Mr. Chairman. Members of the committee, I bring to you House Bill 229. As a little background, you heard this in subcommittee last year, and then it went to the full committee. I did not get it out of full committee. There were some concerns that were raised about whether or not we're opening the door up too much for folks to petition or visitation rights pursuant to this code section. But I'll be as brief as I can. You've already heard this once. I'll tell you what we changed from last year. Again, this deals with redefining what a grandparent is in the code section. Grandparent is the one person that can go before the court and petition or visitation rights in a superior court. You do it two different ways. They can intervene in an existing action where custody is at issue, or they can file an original action where the parents are no longer together. So all we're doing with this code section, redefining what a grandparent is and including aunts and uncles and great-grandparents, one more degree out from a grandparent. And we discussed last year the policy behind this with the way we have a lot of extended family members now that are helping raise kids. And so this just gives standing to get in court if you're not just a grandparent, but you're also an aunt or an uncle or a great-grandparent. What we changed from last year, though, working with the family law section of the bar, we've added a clear and convincing evidence standard you'll see on line 36 and line 37, this whole code section. And so instead of having the preponderance standard, when you're going in and you're petitioning the court to take time away from two parents, you have to now do clear and convincing. I'm trying to go as fast as I can. I know it's getting slower. A clear and convincing evidence standard. Not going to tack anything on here, but
you need to tack on a little speed.
I was trying to go a little faster, but I'll slow down some. We also, on lines 38 through 41, added in that we're confirming that the mere absence of an opportunity for a child to develop a relationship with a family member is not considered harm. In other words, there's a presumption there in this code section deals with showing harm. And we're confirming that you have to have a pre-existing relationship. We don't want someone going into court getting visitation awarded that had no relationship with the child previously. We also confirmed that again in lines 67 and 68 of the bill. And one last change we made from last year, lines 73 through 76. We still have the 24-hour minimum that's currently in the code that a judge must order if they do award visitation rights pursuant to this code section. But we confirmed that if there's multiple actions, if for some reason multiple people do go file under this code section, that a judge can use that in the aggregate instead and determine how they want to award the 24 hours amongst the different people that have filed in that action. And I don't know if she made it into the room yet, but I have to say she's on her way. I told her that we were being reset this afternoon. But Jessica Patton is a constituent of mine. Will be here in a minute. She brought me the idea for this bill. She was in a situation where she didn't get to see her nephew anymore, a nephew that she helped raise. And she wanted to go to court to petition for visitation rights and learned that because she's not a grandparent, that she cannot petition for visitation rights just because she is an aunt. And I also had a great-grandmother that reached out to me about the same time, completely unrelated situation, that helped raise a great-grandchild. Wanted to file a petition under this code section and was denied by the court standing because she was a great-grandparent. And so we're trying to go out one more degree from just grandparent and give more folks standing with this bill. And with that, Mr. Chairman, I'll try to be as fast as I could. I know I went very quickly. But I'll be happy to answer any questions anyone has.
Okay. Representative Welch.
I think you have someone that wants to speak, but at the proper time, I'll have the information.
Okay. All right. Is any questions from the committee? Seeing none.
Yes, very briefly, if you don't mind.
All right. What's your name?
My name is Chase Wilson.
Come on up and introduce yourself.
I'll be brief. I won't take up too much of your time. My name is Chase Wilson. I'm a family law attorney. I practice at Davis, Matthews, and Quigley here in Atlanta. I came last year and I spoke out against this bill, and I'd really like to thank Representative Strickland for working with me and working with other members of the family law community to make some changes to this bill that I think will improve the law for children in the state of Georgia. At the heart of this issue, there's a fundamental sort of disagreement. Some people think that the decision of who a child should be allowed to visit with solely resides with the parent, and it's a sort of a very sacred thing to take that away. Then there are others in the family law community that would say that there are plenty of situations, plenty of factual situations, like Ms. Patton's situation, where a family member who has a close bond with a child has been somehow arbitrarily and wrongfully denied access to that child in a way that's harmful to the child. I think this particular legislation, as it's drafted now, has addressed concerns by sort of people in both camps. It broadens the class of who can seek visitation and time with a child over a parent's objection, and it also clarifies, it incorporates existing case law with the clear and convincing evidence standard, and clarifies one area where certain family law practitioners have seen abuse, and that is where in cases where there is no existing relationship but there's been a award of visitation. Anyways, thank you all for your time, and especially thank you to Representative Strickland for working with us on this.
And so you support the bill?
I do. I
Okay.
do.
Okay. Does anybody else like to speak to the bill? Seeing none, Chair will call the question on the bill. Entertain a motion.
Mr. Chairman, I make a recommendation to pass.
Okay.
My committee substitute. And the LC number is 2970007S.
Okay, we have a motion do pass. And it's seconded. The bill's on the breast of the committee. Is there any further discussion, comment from the committee? Seeing none, Chair calls a question on House Bill 229 LC 297007S. All those in favor of do pass recommendation indicate by saying aye.
Aye.
All opposed, no. Passes unanimous.
Thank you.
Sir, you're on the rules. That should be in there today.
Thank
Did you want to do this one at all? While he's speaking?
Which, yeah, hey, before you go anywhere, since you have, I'm going to add this to the agenda. This will be House Bill 1073. And I know that a gentleman from the State Bar of Georgia, Mr. Worthy, I believe is his name, has some people coming. You might want to sit. You might want to sit down and send a text or two, if possible. See if you can get that squared away, and then we'll come back to you in just a minute. Okay.
Okay.
All right. Next bill we're going to call House Bill 725, and this is. Let's see, whose bill is this? This is Wes Cantrell's bill. I don't see him here right now. Accordingly, I'm going to take care of this bill. I'm going to present the bill. We have made some changes from last night, and the reason this bill was held over was primarily because, well, for several reasons. And if you'll we'll go from the back and go forward. If you'll look on lines 249 through 250, the bill was written where if there was a violation of the terms of the bill or the code section, then the punishment would be someone would be guilty of a misdemeanor. Now, what this bill has to do is Child Advocacy Center records and records that are related to child molestation, and it's the forensic interview, things like that, and the documentation, photographs, digital format, images, and what this does is if those documents are leaked, then it can be punished by contempt of court, which is, I think, a better policy, because if you have a willful and intentional leak of records that are protected in accordance with this bill, then that should be punished. The thing about contempt is it has to be a willful, intentional violation of a court order. And that's the distinction. Now, if you have a big file that you're sending somewhere and somehow a one or two documents inadvertently get disclosed in that big file, or somehow it gets transferred, that's not a willful. That may or may not be a willful, intentional violation of the court order. So I think that what it does is it puts discretion in the trial court or the judge. The judge who's making the decision in the in-camera hearing about how to handle the issue on contempt. Well, it may not be the judge in the in-camera hearing, but that's what could happen there. Now, and that's the change we made there. What's that?
That's the next one, 215.
And then on line 215, after a party has made an application for to obtain these records. Now, this applies in the civil and in the criminal context. I think my microphone's going in and out. Does it sound like it is to y'all? Okay. Line 215 now reads, after an in-camera inspection of such records, the court finds that access to such records appears reasonably calculated to lead to the discovery of admissible evidence. Number one, in a criminal situation, a judge, and if it's a criminal situation in this kind of case, I would expect that to be primarily a superior court judge. It may be at times a state court judge, depending on whether the charges are misdemeanor or felony. Either way, they're both going to be lawyers. They're both going to, I hope they'll be very familiar with criminal procedure, and they're going to be able to make a decision on whether these records should be disclosed to the defendant. And that's in a criminal situation. In a civil situation, we could stay here for a year and come up with different fact patterns that, and we still wouldn't cover them all. It's just something that a judge has to do, in my opinion, and I practice this very regularly in my practice. So, and in the civil situation, it could be an issue of divorce, where custody is at issue, or any other case where custody is at issue. When someone is seeking custody, a defense that can be put up is that the party seeking the custody of the child is not a fit parent. These type of records would go to the fitness of a person to be, whether they were fit to be a parent or caregiver to a child, and visitation for that matter. So that's the rationale that I feel is the policy that supports this change. And the language in there previously would have required the court that's doing the in-camera inspection of the records to make a decision about those records as to whether they would be admissible into evidence at the trial. And that's at the in-camera hearing is generally only between the parties, or more likely just the lawyers will be there, and you don't have the benefit of having a court reporter, wouldn't have the benefit of having the ability of the court to have witnesses, and accordingly, it's just not a good forum for that situation. Later on, it could still be precluded from evidence, but that would be in a situation where you have the totality of the trial coming to bear upon it, where you have witnesses, you have other evidence that may be brought, and a decision at that point would be, first off, whether it's material and relevant and bearing upon the issues in the case by the judge. So that's the rationale behind that change. What's the next one, Jill? Then on page 3, line 76, we just struck line 76 through line 79. And that's just we don't want to exclude those records that have a time limit, and the reason for that is this will apply not only to criminal records but also to civil records, and well, that's one part of it, and then second is or another reason is criminal records may be relevant in a criminal prosecution of a subsequent crime or alleged crime. And I think that's it. Right? That's it. Any questions from the committee? Let's see who we got. Is that you?
Mr. Chairman, when you have a minute, I'd like to make a motion, recommendation do pass.
Okay.
And this has been vetted. I think this is heard 4 times, I believe. This is the fourth meeting on this bill, I believe.
I think it is. All right. Do I hear a second? Okay. All right. Representative Spencer.
I was going to make a motion, sir.
Okay. Thank you. All right. Anybody commenting on the bill, House Bill 725? Anybody in the audience commenting on the bill? Hearing none, the chair calls a question on the motion do pass. All those in favor indicate by saying aye. Aye. All opposed, no. Okay. Representative Strickland is here to present House Bill 1073. Representative Strickland.
Thank you, Mr. Chairman, members of the committee. I have House Bill 1073, and I have Thomas Worthy here with the State Bar who may come fill any gaps of anything I leave out. I'll be as quick as I can, Darshan, without talking too fast. 2 parts of this bill. The first part deals with what happens to a final judgment when it's been appealed, what happens to the underlying case. And this section confirms that other than a petition to terminate parental rights affecting an adoption proceeding, other than the adoption proceeding moving forward, all other proceedings in connection with the underlying case can still be ruled on by a court and move forward, despite the fact there's been an appeal that's been filed. Apparently, this is kind of a logistical issue that some have had in juvenile courts with this, and so that's what that first code section is dealing with. And again, Mr. Worthy can add more to that if you would like. And the second section just confirms, we didn't have this in our code, that when you have someone waiving counsel, other than the child, that we also have that the waiver has to be knowingly, voluntarily, and on the record, just to make sure we're clear as what our intent is with when someone does waive the right to counsel. I've always seen that in all proceedings myself anyway, but it has to be on the record, and the judge has to make sure that's knowingly and voluntarily as well. And Mr. Chairman, I know the hour is late. I can pass it on to Mr. Worthy if you want to say anything to it if you'd like.
Sure. Thank you, Representative Strickland. Thank you, Mr. Chairman. This bill came out of the Child Protection and Advocacy section of the State Bar. To give you a little bit of a history, as you know history? All right. This came out of the Child Protection and Advocacy section of the State Bar. It has been vetted by the practitioners in that section, and we certainly we have a representative here from that section if you have any substantive questions, but we certainly would appreciate a do pass recommendation.
All right. Representative Spencer.
Motion at the appropriate time, Mr. Chairman. Do pass.
Okay. All right. Motion do pass. I hear a second. Okay.
Just a question.
Chairman Welch.
Just a question. I want to make sure this is clearing up in our juvenile justice code that we passed before, giving parental right termination to the juvenile courts. We're just now clarifying that freezes the adoption process if it's on an appeal.
Yes, sir.
So that way, anything coming out of that order doesn't allow the adoption to go forward and bonds to be built that would otherwise need to be severed should the Court of Appeals decide to reverse.
Yes, sir. Okay. That's exactly right.
Record that so that next time.
Any other comments from from those in the audience? Ma'am, I'll be glad for you to address the committee if you'd like. Okay.
Worthy has aptly expressed the views of the committee.
Thank you for being here. I'm sorry we're still in session over there, and we're kind of got a little mixed up, I think. But I appreciate you being here, and I appreciate the work that the bar does and the committees on the bar. Without your input, it'd make it very, very difficult to really get the organic nature of these bills prepared, and it's a lot of work. Thank you very much. And would you please express all of our collective appreciation to the rest of the members? All right.
Need a vote?
That brings us to
We got to call a vote. We haven't voted yet. Just have the motion. Oh, sorry.
we got a motion to do pass, right? Okay. So I'm gonna call the question on the original issue. Motion do pass LC 296987, House Bill 1073. All those in favor indicate by saying aye. Aye. All opposed, no. Unanimous. Okay. Thank you very much. All right. What do you want to do? Representative Raffensperger. We're going to crank it up. Just hang on. Well, we're not going to stay there. He's going to do it. Representative Raffensperger.
Mr. Chairman, thank you, and committee members, thank you for allowing me to present this bill today. This has gone through and a little bit of rework as it's gone through the process. The Senate has a bill that's, I understand, is very similar to ours, if not identical. They added the legitimation clause. So, Mr. Chairman and committee members, we heard testimony when this was in subcommittee that there's actually people situated in Georgia that this situation has occurred. I first heard about this lady named Shauna Pruitt. She was going to a university up in Illinois, and she was a college student. She was raped. She became pregnant, and then the rapist realized he had parental rights, and based on those parental rights, he used that as a sledgehammer so that she wouldn't testify against him. And that then led her, I guess it led her to law school and led her to work in probably about 30 states now with restricting the parental rights of rapists. So what you have before you today is a bill that would restrict the parental rights of the rapist when the child is conceived as a result of the rape in violation of Code Section 16-6-1. Legitimation was added because what that does is would allow, in the instance of a woman that needs it, the mother, child support, so that she's not left out there without any money, as I understand it. And that wasn't in the original bill. I know that there is some talk about does this ever happen in Georgia, and all I could do is refer back to the statewide report of Reported Crime Index from GBI. And in 2014, there were 2,091 rapes. And detailed studies, which I sent out to the committee earlier through email, Giving Birth to a Rapist Child by Pruitt, The Parental Rights of Rapists by Bitar, and the Northwestern Journal of Law and Social Policy, Due Process and Legislation Designed to Restrict the Rights of Rapist Fathers by Kessler. They came up with a statistic that about 4.7% of all rapes will end up in pregnancies. And a lot of people think that, well, when a woman gets pregnant due to rape, she just goes out and gets an abortion, takes care of it. No, actually, they said that probably it could be up to 75% of all these ladies are actually bringing a child to term. So based on that statistics, we could have 98 pregnancies due to rape in the state of Georgia each year. And so I'm standing there today to represent, those voices, those people. I think in a civilized society, this is an injustice, and I think this is good legislation, and I would just ask for your, favorable consideration today. Thank you.
Okay, thank you. Representative Spencer.
At the appropriate time, Mr. Chairman, make a motion to pass.
Okay, well, hang on just a second. Chairman Welch.
Thank you, Mr. Chairman. Just a question for you, Representative Rathsberger. What is in the legitimation process, would the court not already consider this such a heinous crime being perpetrated as not being in the best interest of the child, to have the father that committed this crime being legitimated as the father? I mean,
Well,
we already have that presumption built in the law, or in other words,
That's really not, because we've added that on, in Section 1, paragraph G, caused his child to be conceived as a result of rape.
Mhm.
So it's not really mentioned right now. And so this is actually, bringing it out and adding the additional force that it would actually be spelled out. Right now, we talk about things as abandoning a child, aided or abetted, attempted, conspired to commit murder, subjected a child to torture, and yet we don't have that specifically spelled out. So this would just provide an additional support, additional protection for a woman who has been raped.
and as a follow-up, Mr. Chairman,
Representative Welch, Chairman Welch, excuse me.
Without being able to present this presumption and to work changing or making clear in Georgia policy that there's a presumption against the perpetrator of the rape becoming the parent of the child or having parental rights. Does that not also facilitate the ability for a child to be adopted because you're less likely to have a father that may intervene in that adoption by trying to legitimate the child and cause problems with that adoption process?
If I've heard your question correctly, I believe you're correct, that if the woman wanted to give the child up for adoption then, and you still have this rapist out there trying to hang on to his parental rights, that would be a wedge issue, could preclude an adoption.
Thank you.
Thank you.
Representative Kendrick.
Thank you, Mr. Chair. I have 3 questions. How many can I ask?
You can ask your questions.
Okay. The first one is on lines 33 and 34. What does it mean, and the court shall specify the name in which the child shall be known? Are you talking about the last name?
I believe that's the intention there, yes.
Okay. And then the lines 34 through 35 says, if the court determines that the father caused his child to be conceived as a result of rape in violation of the code section. So this would be a separate determination apart from, I don't know, a conviction?
Correct. The standard for this, because it's civil, would be clear and convincing evidence.
Okay. And the last question is 37 and 38 is creating a presumption against legitimization. And I don't know if this was a compromise piece, but I thought the original sort of intention of the bill was to, if the court made the determination that the child was conceived as a result of rape or some other violation, was to terminate legitimization. Do you see a scenario under which the court makes this determination, and then through a series of facts, the court still ends up being able to legitimize the father or give rights to the father for the child that was conceived by rape?
That is a very specific question. Can I defer to legislative counsel on that one?
Couldn't it defer with actually the mother and reconciliation? The mother agrees to it?
The division of the bill has to do with adoption and parents that are married versus Section 2 of the bill, which is legitimation, which the parents are not married. So the standard is different in the adoption and the juvenile court. We call it presumption. It doesn't use that word presumption, but when you have an aggravated circumstance, I think you get towards that area of presumption. In terminating the parental rights in Title 15 and Title 19, adoption Title 19, Title 15 Section 1 of your bill, versus Title 19 Chapter 7, which is legitimation. And that's what you're doing with the bill, is in those 3 areas of the law, you're creating it. We actually use the word presumption in Section 2 of the bill versus Section 1 of the bill. It goes in aggravating circumstances, then it's used elsewhere in the juvenile code, and then the circumstances are listed out in the adoption code.
Thank you.
Representative Kendrick, anything else?
Nope, that's it.
Okay. Thank you. Okay. Any further questions for the presenter of the bill? Is there anyone out there in the audience that would like to speak to the bill? Okay. State your name again.
Joshua Edmonds with Georgia Right to Life, Director of Education and Legislation. I'll be very brief. I know the hour is late. Just wanted to speak in favor of this bill. This is priority legislation from Georgia Right to Life. There is a version over in the Senate, Senate Bill 331, which does have the same language in it. It's passed out of Judiciary and Non-Civil Subcommittee and full committee and is in Rules Committee right now. This bill has been passed unanimously by the Michigan State House and Senate. The Iowa House committees unanimously voted. Indiana House unanimously voted it out. So this is a bill that has wide bipartisan support and is aimed to protect innocent women and children and help create a defense against heinous criminals who are victimizing women and children. I just ask for your favorable consideration.
Okay. Is there any questions? Representative Welch.
Not here, but it's a standard in the juvenile code, I believe, too.
The chair has a question. I want to pose a question. Now, first off, the procedure for legitimation in the state of Georgia and the standard for the court entering an order of legitimation requires that the court make a decision that legitimation is in the best interest of the child. Now, to me, it seems like if the mother has been raped and the child is, in fact, a result of the rape, then a judge would be able to take that into consideration. And just in my experience and in my I think my logical mind, it would be whatever part of that I happen to be in. I think it would be extraordinary for a judge in the state of Georgia to find that a person who that judge believes raped the mother and created this child to be a fit parent. Could you just comment on how you feel like that the process that's in place in the state of Georgia applies in this bill?
Sure, and ultimately on matters as the chairman discussed, I would defer to the author or other capable members of the committee or legislative council. I know in section 2 it says in lines 31, 32 that if the court grants such a petition, so it does sort of have that inference there that if you get to this point that a petition for legitimation is granted, that if the court determines that the father's conceived caused the child to be conceived as a result of rape, down at lines 34, 35, that's where that would kick in. But I know that there's a young lady who testified in subcommittee for juvenile justice. Her name is Sarah Hughes, and her story is similar to this. That she was dating a young man who drugged her and raped her, and she didn't learn about the rape until later when she discovered evidence on his phone that he had actually perpetrated a rape against her. And as the proceeding went forward, he was able to legitimize the child because her attorney had told her not to bring up the issue of rape during the legitimation hearings, and so she did not. And he was legitimized here in Georgia in Forsyth County. And so there have been situations in Georgia where a mother was raped to become pregnant, and for whatever the reason, she did not bring that up during legitimation. Her story is that she was told by her attorney that if she brings the issue of rape into the conversation, it opens a can of worms where people might begin criticizing her character because she was dating this person and call into question her character in other circumstances. And the easy thing to do is to leave it out of the conversation and honestly silence her from being able to seek justice against a violent offender because the rape took place in another state. So this is just a safeguard for situations like that. Georgia Right to Life believes if there is one person who is being victimized in this way, that it is incumbent upon our state legislature to do what's necessary to protect those citizens here in Georgia.
Okay, thank you.
Mr. Chairman, if I may.
Yes, sir.
We also had another bill that's working its way through the system by Representative Holcomb.
Okay.
Okay.
I tell you what. I've got a couple more questions. I'm going to take these questions and then we're going to see what the will of the committee is. Representative Sharper.
Thank you, Chairman. Just quickly, in that case that you're talking about, was the person convicted of rape?
No, sir, they were not.
Okay, and that's what, the thing I'm talking about. I understand the whole point, but anybody can easily say somebody was raped, but unless you have a conviction of it, even if you're talking about that person bringing it up, in the hearing, because you can't bring that up because it wasn't a rape unless, pretty much is convicted rape. We can always, say it was, but unless you were convicted of it, we can't say that, can we?
Well, in subcommittee, if I may, Representative Quick had spoke to that issue.
Okay.
This being a civil matter, not a criminal matter, she compared it to like a car accident, where if there were a charge of fault criminally for a car accident that resulted in injuries, that will be one case, and separately there could be a civil case for damages, and the burden of proof can be different across the two cases. And because this issue of legitimation would be civil, not criminal, you cannot require a conviction and still seek a civil case similar to these other circumstances.
Okay.
Further to that point, in right now, current code section 15-11-2 OCGA, it states that clear and convincing level of evidentiary standard is adequate to terminate parental rights already for actions that I would consider less than, rape.
Okay.
And so that standard has always been held. And then furthermore, really in Santosky versus Kramer, in the U.S. Supreme Court decision, they said that the clear and convincing standard was a standard, so it would be constitutional. But also, as Representative Quick said in her previous testimony, she used the term res judicata, whereas one court, civil versus criminal, they don't really transfer direct to direct, and clear and convincing standard is the appropriate standard for a civil matter.
Okay. Thank you.
And Representative Raffensperger, can you just indicate where in the bill that the clear and convincing standard is required?
I have to get up my... So line 46, when the court determines by clear and convincing evidence,
And then they're adding that. This, and that's related to adoptions, right? Mm-hmm.
that's in section 3, and
That, yeah. Okay. All right. Okay. Representative Dickerson, I'm sorry.
I guess I was trying to question lines 34 through 35, but in this section, you're saying that there's evidence that this person, because of the DNA and all of these tests that they've gone through, that they are the person that has actually caused this rape. Is that correct?
I apologize. I don't really understand
Okay,
the
what
question.
I'm just trying to understand is that when you're talking about the legitimization of the person, a perpetrator, that there is clear and convincing evidence that he is the person. Okay.
Correct.
That's what I was. Okay. Thank you.
Yeah, legitimation would include that.
Okay.
Yes,
Thank
ma'am.
you.
Representative Welch.
I think that there is a legitimate concern here amongst members of the committee about the court's method or manner and burden of proof in terms of determining that whether the rape has occurred or not in accordance with the criminal code section. So since the standard has usually been clear and convincing, and I think that would add a level of comfort in that determination, I have an amendment to add the language there at line 34. And so it would be after the word determines, we would insert the phrase by clear and convincing evidence.
We have a second. Okay.
You want to do that after we get a motion?
Yeah. You're making a motion, right?
This
Yeah, we got to have a motion to pay.
Spencer
Okay.
want to make the representation.
Before we're going to suspend on the amendment, just a second. The chair will entertain a motion on the question regarding LC 29, 69, 59, 58S, House Bill 713 by Representative Raffensperger. I'll entertain a motion.
I'd like to make a motion to pass. Second.
Okay. All right. Now, is there there's an amendment?
Yes, sir, Mr. Chairman. You want to do it?
Okay.
Okay. Then I'll make this amendment. I'll let Representative Kendrick make the other one. One amendment to be proposed is at line 34, after the word determines, insert the phrase by clear and convincing evidence.
Okay. There's a second. All right. Any discussion of the amendment? Seeing none, Chair calls a question on the first Welch amendment. All those in favor indicate by saying aye.
Aye.
All opposed, no. Okay, pass. It's amended. Now, Representative Kendrick.
This is more. Can I ask a question to
Sure.
see if my amendment is needed?
Sure.
So my concern for going back to lines 34 through 35 is I don't see in here where a conviction would create a presumption, but I do see on line 36 where it says an offense which consists of the same or similar elements under federal law. Is an offense used as a euphemism for, I guess, a conviction?
I'm going to defer to counsel on that.
So we're nowhere requiring conviction.
Mm-hmm.
We're requiring a violation, the elements of what would be a violation of 1661, which is rape. In South Dakota, it may be called first-degree rape and have the same elements. And so we're saying an offense that has similar elements as a violation. None of the locations were requiring convictions. That offense language is similar to like what we do for the sex offender registry. You may not have been convicted of a registrable offense here in Georgia, but it's an offense that's similar in another state that would require registration.
Right, and I'm not asking to require conviction. I guess I'm asking, could we add that a conviction creates the same presumption as if a court determines that the father caused the child to be conceived as a result of rape? Instead of the court going through all those elements, if they have a conviction, why does that not create the...
I think the conviction would be the
Yeah, that would be the evidence.
Yeah.
the judge could just use that as the basis of the spot.
Representative Evans.
I'm sorry.
They could, they could use it. I guess my issue is, why don't we put in the statute that automatically creates it? And I'm not trying to be difficult. I support the bill. I'm just asking if there is any conflict in adding that language, because they could use it, which I agree, but is there a problem putting in there that it creates one automatically?
Well, the evidence would be, in a situation like that, I believe what the evidence would be likely to show, they would come in with a certified copy of the conviction. Then in that conviction, I believe it would also show the punishment that was imputed or given to the defendant. And so if you have a situation where he's charged with rape, then you have it knocked down to a misdemeanor with 12 months probation suspended upon payment of a $200 fine, then that makes a different situation. That's still a conviction, but if let's say it's a lesser included offense, then it's still a conviction based on the alleged crime. But if I saw that in a rape situation, I would have not very much confidence in the fact-finding process and in the conviction itself. And that's a policy concern. I think when they bring that evidence in and they show it, I think just like Representative Evans said, that's going to be a compelling issue, or not, if it's a lesser included, or if it's something that has a punishment that's nowhere near what should be what's reasonable for the crime alleged. So I think that where we have it now, it gives a balance, because this could very easily be tipped too far, where you have allegations of rape, and then you have a plea offer that's significantly reduced from the punishment that could be involved in a rape, and it just mitigates the substance of the evidence against the person. And I don't think the intent of this bill is to give a tool to someone who would say something false just in order to keep a parent that, but for these false allegations or these allegations, is a legitimate parent. And I have seen that in my practice. I've seen it myself. And I've been before a judge, and we had a full 4-hour hearing on why my client should see this child as not a threat to the child, and dealt with that issue. And we won, by the way.
Thank you, Mr. Chair.
I know that's the most important thing. So anyway, and I don't think that's what the intent of the bill is.
Call the question.
Okay. Any other questions from the committee? Seeing none, the chair calls a question on LC 2969-58S as by committee substitute as amended. All those in favor indicate by saying aye.
Aye.
All opposed, no. Unanimous.
Thank you, Mr. Chairman.
Thank you. Thank you very much.